Okay, Shannon, you can put us on the record, please.
Okay.
This is a matter of Jeffrey Snyder et al. Versus Lower Springbrook Intercounty Drain Board and others. So let's start with the council that are present in the courtroom. Can you each identify yourselves for the record?
Douglas Donnell, appearing on behalf of the plaintiffs, and with me is Jackson County Drain Commissioner Jeff Snyder.
And let's see, Mr. Hedrick, identify yourself.
Yes, Your Honor. Cole Hedrick with Fahey Schultz Berzik Roads on behalf of the Drainage Board.
Ms. Hissong.
Yes, Stacy Hessong from Fahey Schultz Berzik Roads on behalf of the Drainage Board defendants.
Ms. Allison Yoakum.
Yes, good afternoon, Your Honor. Danielle Allison Yoakum on behalf of the Michigan Department of Agriculture and Rural Development Director McDowell.
And I've got Ruth Ann from Eaton County. Could you identify yourself?
Yes, I'm here on behalf of the Eaton County Drain Commissioner.
All right, what's your last name?
Clarke, Clarke.
Thank you.
You're welcome.
And then Mr. Paul Pratt, can you identify yourself?
Yes, I'm Ingham County Deputy Drain Commissioner.
All right, and I don't see everyone else that's in the waiting room, I believe. Wait a minute. No, I think everyone else is related to another case. So we're here on a motion for summary disposition. And let's see, who's the moving party on that?
The Drain Commissioner. Or I'm sorry, the Intercounty Drain Board.
All right, go ahead.
All right, thank you, Your Honor. As you're aware, this case is about adding lands to an already existing drainage district under the drain code. There's nothing more exhilarating than talking about the drain code on a Monday afternoon. So I thought I'd do a little bit of a deeper dive on section 197 because the issues that are the heart of this matter deal with some recent legislation or changes to 197. So many drains were established over 100 years ago in the drainage districts, which are the contribution areas that pay the costs for drains, were set up at the time that the drains were established. And with drains that were established in the 1800s, as you can imagine, many of the drainage district boundaries established over 120 years ago are no longer accurate. And that could be for a myriad of reasons. Our survey equipment has become more accurate. Land use has changed, impacting watershed boundaries. Boundaries were set up based on large parcels or municipal boundaries at the time rather than watershed lines. And it could be lots of other reasons, political reasons. Who knows how the boundaries were set up each time these drains were established. Historically, under the drain code, there were very limited tools available statutorily to revise a drainage district boundary that was no longer accurate. There was no means whatsoever before the recent changes to 197 to remove lands from a drainage district, and very small means, only a few means to actually add lands to a drainage district. Lands could be added within one county only through a maintenance and petition project with a reconvened board of determination, or through an appeal process by a board of review appointed by a probate court. So those were the only two mechanisms available before these recent statutory changes to add lands. And the only way you could add a county to an already existing county drain was to go through the petition process in section 135 of the drain code. That was basically the same process as a brand new drain. So it was very difficult to do that, and a project had to be associated with each change, and you could never remove lands. So in 2013, the legislature made some significant changes to the drain code in this area, specifically in section 197, to allow for revisions of drainage district boundaries without the need for a project. So Public Act 261 of 2013 was passed and went into effect in December of 2013, and it provided for the revision of drainage district boundaries for both county and inter-county drains without a petition project. So after these amendments, there was an easier way to fix wrong drainage district boundaries, so to speak, by two different methods for an inter-county drain to add an additional county. The first one was under section 197.3. After an inspection of the drain under section 196, a drain commissioner or a drainage board could request the addition of a county or counties or the removal of a county or counties. After this legislation passed, drain commissioners across the state have been initiating these types of proceedings all over to correct past deficiencies. I just had one of these last month. I have 2 others scheduled in the Thumb area for later this summer. Section 135 is the other way that you can do it, with a petition by municipalities or property owners specifically asking for the addition of a county. So with the passage of 197, really the only time that petition process in section 135 would be used if the drain commissioner basically refused to add a county and the property owners wanted it added to have more people help pay. Some drain commissioners don't like dealing with inter-county drains, so they just don't go through the process, and section 135 would be a means of basically requiring the process to be initiated. So if a county is proposed to be added under 197 sub 3, then a hearing is held with notice provided to the property owners in the impacted areas to add the county. So there's a hearing where it's decided should a county or counties be added, or the opposite can happen in 197 sub 3, a county could be taken out if there was a watershed change. And that happens because I've seen that happen in a number of situations where a state highway goes through and basically blows out the drainage on either side. And so you could have a reduction as well as an addition. The final step is after the hearing is held and a county is added, lands from a county are added, then the drain commissioner holds the very specific hearings about each parcel of land subsequently. So you'd have a hearing like we had in December to add the counties, and then you'd have a subsequent hearing in each county to hear objections to the addition of a specific piece of property within that county. After that is done, then it is finalized in an order revising the drainage district boundaries. Section 197 provides an appeal for this process. So to add a county or remove a county, specifically the last sentence in section 197 subsection 7 talks about that. It provides the means in the same manner provided in section 106, which is an arbitration board. And then a very different appeal is for, with the addition of an inter-county drain, is for the apportionments that would also, so there's an appeal to add the county itself. Just should the county be in or out? That's an arbitration through 106. If there's an appeal of the percentages between the counties, that would also be an arbitration through 106. And then at that second hearing where we go into the, what I'll say, nitty gritty about specific properties, for instance, like the Meads properties, then you have after that second subsequent hearing, then you have the opportunity to appeal for circuit court as to that decision made by the drain commission.
So let me stop you there. When you cite 197.7 in the last sentence, which talks about the reference to section 106 and the arbitration process, what about all the language before that that talks about the right to file in circuit court? So how do you reconcile those?
Well, the first few sentences talk about the owner of any land in a drainage district. So that would be like the plaintiff Meads. So the owner of any land in the drainage district, MDOT, which receives an assessment, any city, township, or village, or county having any control of any highway in the drainage district. So that section, the first few sentences of subsection 7, really deal with the specific addition of properties, not counties. That is the subject of that second hearing. And the last sentence specifically deals with the drain commissioner is the appellant, not a owner of property, and that goes to the arbitration board. The drain code deals with disagreements between drain commissioners and arbitration through a proceeding like section 106. And the first parts of subsection 196 sub 7 deals with the owners of property or anybody receiving a specific assessment that goes to circuit court for this 197 process. Do you have any further questions on that before I go on? And I'll cover it a little bit as I go through it.
Give me just a moment. I'm reading it again.
Yeah, and so
the circuit court remedy that's referred to in section 7 or one, section 7, I guess it is.
mm-hmm.
I guess I'm just looking at it. Does not identify a drain commissioner as within the class of the people who can initiate a case in circuit court. Am I reading that correctly?
I believe that you are, Your Honor. That's why the last sentence was added. Drain commissioner disputes and appeals go to the arbitration board made up of other drain commissioners.
All right, you may continue.
Thank you, Your Honor. So in putting together this today, I realized that I did you a great disservice by asking you to look at a transcript that talks about a map in great length without providing you with a good copy of the map. And so if the court would permit me, I'd like to share my screen with a map of the drainage district. That might be more helpful if I could do that.
Go right ahead.
Thank you, Your Honor. Cole, I'm very inept at sharing my screen, so I'm going to have Cole help me with that. All right, so the Spring Brook itself is a natural water course that begins at the top of the map in the red, where it hooks up with the Grand River. And Cole, if you'll have your mouse follow basically all the way down. So you have what in the red is the Spring Brook, lower Spring Brook intercounty drain, then a point of natural water course.
Are you going
it goes
upstream right now or downstream?
So it flows to the north. The map, the north is on the top, and so
upstream.
It flows from the south to the north, correct. And so, but we call that lower and upper. So I'll just, and so we go upstream, then basically down through the Springbrook intercounty drain. So that purple area.
So the light blue portion that you just traced,
yep,
is not itself a drain.
Nope,
correct?
It's the same physical water course. And if you go all the way down through it, Cole, we have 4 sections of this water course. The red section is established as what we're now calling the lower Springbrook intercounty drain. Then you have an area of natural water course that no one has jurisdiction over. Then you have the Springbrook intercounty drain, which was established in about 1964. And then you go all the way down to the end, and that's all natural water course. No one has taken jurisdiction over that. It's all the same water course, but you have 2 separate and distinct intercounty drains, and then an area of water course that I would define as no man's land that no one can do any work on at this point. And all of that flows through the red area and outlets into the Grand River in the city of Eaton Rapids. So with the lower Springbrook, which is the red portion of the water course that we're now calling the lower Springbrook Intercounty Drain, that was established with proceedings that started in 1882 and completed in 1884 through some condemnation, etc. And it only included a small part of the water course that was only in Eaton County. Why they didn't include the entire watershed for the Springbrook, I have no idea. I know that it was contentious looking through the files and there was condemnation, but they did not. So since 1884, only a handful of Eaton County properties have been paying for the outlet for this entire watershed. And then we have that natural.
So the gray shaded area is the entire area drained by this water course and the connected
tributaries.
Drains.
Absolutely, yes. And that was what the engineer first provided to the drainage board for purposes of a proposed drainage district and the addition of lands. So the first drainage district back in 1884 didn't even include all of the lands in Eaton County. It just included a small subsection. And again, for the life of me, I don't know why they did it that way, but they did. And my experience is it's not that unusual in doing 197 proceedings all over the state. Almost every drainage district is not accurate. And that's why everyone's going through the process of fixing them. So then we have the purple section.
So let me stop you again.
Yeah.
If someone were proposing today,
yeah,
to create a drainage district, and there hadn't been any other drainage districts in this watershed area, would the entire watershed have to be included in that drain?
All right, so I'm going to make sure I understand your question. So if there was nothing established on the Springbrook at all, and you wanted to establish the outlet, then my answer would be yes, if the drainage board proposed that that was what it was going to do. If it was in the purple where they were proposing to establish it, then the answer would be no, because the purple drain doesn't everything in that light blue area doesn't contribute water through the purple. Only a part of it goes through the purple. So it depends on where you're saying that would be, Your Honor.
Let's say it's at the red portion right now. If there were a proposal today to make that a public drain, would it have to include the entire watershed?
So have is a big word, but I'm going to say that the drainage district engineer would most likely propose the entire watershed. And then there would be proceedings to go through to make sure that that was accurate.
But he wouldn't have to propose that. He could propose something less.
Well, yes, I believe. So again, this is a new drain. The drainage board, the engineers would have to propose what they say is the entire watershed as a licensed professional engineer. And then the drainage board could vote as to what they wanted to include. And there could be appeals that would be inaccurate.
All right, I'm sorry, go ahead.
No, these are great questions. That's why I wanted to show the map, and I apologize profusely for not providing it to you before. So you can see in the natural water course, this area between the red and the purple, you have some tributary intercounty drains that flow into that natural water course, and that ultimately flow into the outlet. And then you have the purple Springbrook intercounty drain, which is a completely separate drain from the red, which is the lower Springbrook intercounty drain. And the drainage district boundary that was established in 1964, again, contentious. There were condemnation proceedings for that one as well. It took over a decade to get through the litigation involved in that. And the watershed or the drainage district boundary for that one is not as extensive as what is being proposed for the red one, because obviously everything north of the purple doesn't flow into the purple, it flows into the red. But the drainage district boundary for the purple includes everything south of that through the entire watershed, picking up the natural watershed below it. So it's not just waters that tie in during the purple, it's everything that flows through that is part of the purple. And illustrative of this is, and what I want to talk about when we get to the consolidation of drains, you'll see that the pink drain, the C.E. Walker intercounty drain, flows into the Gurley Lake intercounty drain, which is the blue, which flows into the Peacock intercounty drain, which is the orange. So the folks that are in the pink C.E. Walker intercounty drain, they're already in the pink drainage district, the blue drainage district, and the orange drainage district. And we're saying, because their water flows through all those drains, and we're saying they also need to be in the red drainage district. So it's very possible without a consolidation to be in several drains and drainage districts at the same time. And just because their lands are in more than one doesn't take away the separate entity that each one of those is. There is a C.E. Walker Intercounty Drainage Board. There is a Gurley Lake Intercounty Drainage Board. There is a Peacock one. They're all separate entities because each one of them pays for the water courses that it ends up going through before it reaches its ultimate outlet, in this case, which would be the Grand River. So having lands in more than one drainage district does not mean that those drains got all consolidated. And I'll come back to that in a minute, but this picture is very illustrative to that. So I wanted to make sure I talked about it at the time.
So I remember reading mention of there being some acreage in, I believe it was Ingham County, that's being excluded, even though it is part of the drainage area. And I was just looking for that on the map.
So that would be the little corner in Onondaga Township. And so that's why I was very careful to answer your first question, Your Honor, about does everything in the watershed have to be in the district, even though the engineer proposes it? And I said, well, the engineer has to propose it, but the drainage board can decide differently. And in this situation, that's exactly what happened. The drainage board said it would cost more to do the mailings and the publications in Ingham County than it would to get that tiny little percentage of property in Ingham County. So we're not going to add them. And so that's what happened in this case. So my hesitancy was not trying to be tricky when you asked the question before, it's because this kind of thing happens. And I wanted to explain it.
Thank you.
You're welcome. So that's kind of how the process works and what this looks like physically. So for these drains, you see there's a lot of different drains within the Springbrook or Lower Springbrook watershed. And then after the change in the law, and the Eaton County Drain Commissioner has hundreds of drains, and he has went through, I think, over 197 procedures for different drains in Eaton County. He's finally arrived at this one, looked at it after the change in the law and said, boy, I think we need to make a change here. So he retained engineers to do an inspection under 196, which is required under section 197 sub 3, to see if it made sense or was appropriate to add lands to this drainage district. The engineers came back with the results, and the Easton County Drain Commissioner served notice as required in 197 sub 3 to the Department of Agriculture and Rural Development and the Drain Commissioner from each of the affected counties to convert that drain appropriately from a county drain to an intercounty drain. Because those poor folks in that small district have been paying for the outlet for a massive watershed here. So the proposed addition of lands includes the waters that flow through that whole 4 sections, basically of.
So let me ask you, what are these folks paying for? They're paying to make sure that this water course is kept clear and able to accommodate all the drainage that flows into it?
Yes. Yes. Just like the folks on the C.E. Walker have to pay for the infrastructure to get it all the way to an outlet. That is the outlet that serves every piece of property in that area. And so they need to help pay their portion of the future costs of that drain, which can include maintenance and improvement in the future. So the drain commissioner.
I've got one more question. I think it's the Gurley Lake.
Mhm.
That's the
blue.
Oh no, that's the wrong one. What's that other blue that's in the upper left area?
Great question.
What's all that?
Those are a series of different separately established intra-county drains. So the Mills drain, the Hobart drain, all of those are Eaton County only drains that also flow into that outlet. This map doesn't show all the intra-county drains that are Jackson County only or Calhoun County only. They only show the intra-county drains.
So these intra-county drains are not part of the proposed drainage district? Or are they?
So the lands are, but the drains will still remain separate. Like the Hobart drain is one of these in Eaton County. So the Hobart drain, all the folks in that drainage district will also be in the Springbrook, Lower Springbrook Intercounty drain. They'll have to pay for both drains, but the Hobart drain will remain separately established. So that when work is done on the Hobart drain, the whole watershed doesn't pay for that, just the people on the Hobart. Just like the C.E. Walker isn't consolidated, the C.E. Walker people are the only ones that pay on the C.E. Walker. And then the district gets a little bit bigger for the Gurley Lake. It includes the C.E. Walker and everybody else that's served by the Gurley Lake, and so on. It's almost like Russian nesting dolls, where you have separately established drains and drainage districts that are tributaries to bigger ones. It is not unusual, as the transcript shows, to be in more than one drainage district. I am in my home where I'm sitting right now in more than one drainage district.
Thank you.
You're welcome. So the hearing was held for the addition of Ingham, Calhoun, Jackson. And at that meeting, it was voted on and decided that Calhoun and Jackson would be added with Eaton County, but not Ingham. And for the reasons I explained, that the board decided that it would cost more money to do the publication and the letters than those properties would probably actually pay, and decided to keep them out of that because of the small amount. The board voted to add the counties. Jackson County voted no, but Jackson County was outvoted. And then the board voted on an apportionment between the counties that included a larger than a pro rata percentage to Eaton County, with a methodology partially based on acreage and partially based on the location of the drain being completely within Eaton County. The chair then prepared an order and sent it around for signature, but the Jackson County Drain Commissioner did not sign the order. So I'd like to go into each of the claims and each of the counts to talk about why we believe that summary disposition is appropriate. In count one, Jackson County is appealing the addition of Jackson County to the district. They made clear in their brief they're not appealing the apportionment, and it doesn't appear from their pleadings that they're appealing the fact that Ingham County was excluded, or that Calhoun County was included, just the fact that that Jackson County couldn't be included or shouldn't be included. And then the property owners are attempting to appeal the addition of lands to the drainage district. So what we have is the add in the drain code violations, which is count one. Only the question, as far as the drain commissioner is concerned, of adding the Jackson County lands, and for the Meads, the only question is, should their attempt to appeal the addition of lands? And we don't think that this court has jurisdiction for either of those appeals at this time. The addition of the—
Let me stop you for just a second. It's become quite obvious to me that the folks that are in the waiting room, I'm not going to get to them today. I need to let their attorney know that. and figure out a time to bring them back in. So give me just a moment to do that. Back in. So give me just a moment. Mr. Zaid?
Hello.
I've got another matter that it's obvious to me is going to take up the remainder of my day. I didn't want to keep you and your clients sitting in the waiting room. Is there another attorney you're expecting for this proceeding today?
No, Your Honor. I'm glad that you chimed in. I was paying attention to the YouTube video, so I was wondering what was going to happen. Can you at least tell me who is appearing with me? Who's in the waiting room with me?
I can tell you everyone. Brian Rose, Amber Villarreal, Adam Rose, Deborah Wallen, Melissa Rose, somebody who's logged in as Apple Gator Honda, Cassandra Rose, and probably the one you're most concerned about, Troy Rose.
Beautiful. All right. So no other attorney was going to appear. Judge, I wanted to ask you before the hearing, if I may, for a quick second. I don't obviously want to elicit any testimony because I represent the entire estate. Will you be the one questioning and eliciting the evidentiary hearing information, or do I need to have the estate retain someone on their behalf?
Is your concern just with Mr. Troy Rose or with others as well?
Mr. Troy Rose is still the only person that's going to be offering what he did before. I believe the remainder of them are going to just offer information. I just don't want to ask the questions because I don't want to give the appearance of having an impropriety or having preferential treatment towards any member of the estate. So if you were going to ask the questions of all of them and make a decision, we can proceed, and I don't mind telling them to wait. I know they would like to have this wrapped up. I have everything else signed. But if you did not want to ask questions and you were going to expect me to, an adjournment would be good, because then I can have them hire someone, which I'd rather avoid because it'll be more money away from the family.
I don't mind asking the questions, but it's clear I'm not going to get to this today.
That's fine. I will adjourn. When is a good time for me to do that?
I'll have to have my secretary get a hold of you. Actually, if you want to call my civil secretary, her name is Nadine, and she can set something up. Setting it for 3 o'clock on a Monday afternoon is probably not a good idea. I normally hear dispositive motions at 3 o'clock on Mondays. If I'm going to have to receive testimony, probably certainly earlier in the afternoon would be better.
No sweat. I selected this date. It was given to me. I will. Can I get into one room with everybody to tell them the information at once, and then I'll have my assistant call Nadine to reschedule?
Yeah, let me do that. I'll set up a breakout room and I'll put you all in there. I hope I can do that without bringing them into the meeting.
I'm sorry, everybody.
Yeah, I didn't bring anyone else in, so if they're listening to the YouTube, they'll hear this. But if they're,
you know what, Judge, if
not,
it's tough, I can take care of it. You're in the middle of something. Go ahead and get rid of everybody.
No,
and I will.
No, looks like I can do that. Just
All right,
when you're done in the breakout room, just log out.
Okay, thank you.
Just giving Nadine a heads up too.
Thank you.
And I'm going to have her just tell her to set it for an earlier time.
Yeah, I think that's everyone. All right, I'm going to open all the rooms. Hopefully they'll figure it out. they'll get a command on their screen. The only one that might not is Mr. Rose, Troy Rose, because he dialed in by telephone.
Okay, well, I got his number. I'll take care of him.
Okay, have a good day.
Thank you.
Okay, Ms. Hisson, sorry for that interruption, but I didn't want to leave those people hanging.
I agree. I've been in the hanging situation and I appreciate that the court did that.
There used to be a hanging judge assigned to this courtroom, or at least he would have hung if he could have. Go ahead.
Thank you, Your Honor. So back to count one, which I was talking about the lacking jurisdiction. Let's start with the Drain Commissioner's appeal of adding a county. I think Your Honor correctly noticed that it doesn't talk about the Drain Commissioner in the first few sentences of subsection 7. The last sentence is where jurisdiction lies, and that's clearly with an arbitration board. The last sentence says the addition or removal of a county or counties to or from the drainage district under subsection 3 is subject to review in the manner provided in section 106. I don't think there's any other way that we can read that. If you want to add or remove a county, which the Jackson County Drain Commissioner tells us is all he is asking to do, appeal, that has to go to an arbitration board. Now, in their response brief, they said, Ms. Hissong says there's 2 separate appeals, and I tried to say something different. In the heat of that moment, I just wanted to make sure Mr. Jackson knew that the appeal of a percentage and the appeal of an addition of counties are 2 different things. I did not intend to give him legal advice. I do still believe they're 2 separate appeals, the percentage and the addition of the county altogether. But it is clear that last sentence is the only way to read that. And if you don't read it that way, I don't know why it's there. So in my opinion, the only method to appeal that is through an arbitration board. Drain commissioners hear that appeal in the manner provided in section 106.
And the time for doing that is long past, correct?
It is, Your Honor.
Go ahead.
As to the Meads appeal, I think the first parts of section 197 subsection are correct because they are an owner of property, but it's not ripe yet. All we did was add a county. If you read subsection 197 sub 3, in the middle of it, it says if the drainage district as revised, then basically it talks about holding a hearing under subsection 5. And so subsection 5 is that day of review that would take place in the Jackson County Drain Commissioner's office where the Meads and everybody else in Jackson County can come and look at the boundaries and make their claims. If it isn't changed after that hearing, which hasn't happened yet, then they go to circuit court. So we're not saying that they don't have an opportunity to appeal. They definitely do. But it's not until after that hearing. This was the tentative boundaries to show that Jackson County and Calhoun County should be added, but it wasn't to the specificity of specific property owners. They will receive a notice. We will have a hearing all day in the Jackson County Drain Commissioner's office or a location of his choosing, and then they appeal under section 197 subsection 7. I do not believe it's right.
So I should have brought this up much earlier. Yeah. You keep mentioning the Meads. Let me ask, a long time ago, or very early when I was practicing law, the firm I worked for represented Mead Brothers Excavating. And I remember meeting an Ed Mead as a principal of that business in the course of that representation. Is this the same Ed Mead? I'm frankly surprised he's still alive. Any idea how old he is?
He's in his 80s.
In his 80s? I have no conflict. I haven't seen. I do tell a funny story about an experience with Ed Mead years ago. But I want to disclose that. I mean, like I said, it was a long, long time ago. I don't have any bias for or against Mr. Mead, but if anybody objects to me presiding over this case, you should probably speak up now.
I have no objection, Judge.
No, Your Honor.
All right, I'm sorry. I thought I better say that sooner rather than later. Go ahead.
Thank you, Your Honor. And so it is our position that their appeal is available in section 197 subsection 7, but it is not ripe yet. And the Drain Commissioner's appeal is only under section 106, as it states in the last section, or in the last section. I'm going to move on about the consolidation issue unless you want to talk more about the appeal method.
Go ahead.
Okay. Plaintiffs then allege that we've, in essence, consolidated the drains. No, we haven't. You can be in more than one drainage district at the same time. The addition of lands does not consolidate the drains, does not consolidate the drainage districts to all become one drain. That is a completely different proceeding. This is merely to add lands, and it does not require any kind of improvement. That was the reason the legislative changes to section 197 occurred, to fix inaccuracies without an improvement project. So there is an opportunity to consolidate, but it didn't happen.
Okay, and if they had been consolidated, if that's what had really happened, what would be different than what's proposed today?
What would be different is you wouldn't have a C.E. Walker intercounty drain or an Otter Creek intercounty drain or a Peacock intercounty drain. All of those would just become a gargantuan Lower Springbrook intercounty drain. And anytime you wanted to touch any little tiny part of any water course in this watershed, the drainage board would have to meet and everybody in the watershed would have to pay for it. That is not what happened. Because you don't want to get into the situation where if I'm doing work on one of those little blue drains like the Hobart drain, that everybody in the watershed has to pay for it. Only the little people in the Hobart should have to pay for that because it doesn't affect the entire watershed. So there are situations where it makes sense, but this is not one of those where anybody petitioned to do that. So each separate entity within the bigger entity retains what it is. And so the Springbrook intercounty drain, that purple area, still stays the Springbrooks intercounty drain. It still has its own drainage district, etc. And then the Lower Springbrook encompasses all of it only because all of the water runs through it to get to the outlet. So it is not a consolidation. The only area of drain that drainage board, that specific entity will have jurisdiction over remains the red. And like I mentioned before, you can be in more than one drainage district at the same time. So the people in Parma Township way at the bottom aren't going to have to pay for the Hobart drain at the top because it's not consolidated. The people in Parma Township aren't going to have to pay for the C.E. Walker drain in Calhoun County because it's not consolidated. But they are going to have to pay for the outlet because that's what everybody shares. So this is not consolidation. And we made that clear.
So before the creation of this intercounty drain that brings us all here today, who paid for the red portion when work had to be done there?
Only a little part of the drainage district where those intra-county drains were, and not the entire water course. So you were having, and I'm going to get this wrong, so I'm guessing you're under a couple thousand acres pay instead of tens of thousands of acres paying.
So this drain that I asked about earlier in the upper left-hand portion, or that you said is a different intercounty drain, they haven't been paying for that?
Yeah, so some of them
intra-county, yes.
So if I was on the Hobart, As an example, I was also paying for the lower Springbrook because I was using it as an outlet, but then the people on the Otter Creek who were also using it for an outlet weren't helping. So there was an inequity, and that's why the Eaton County Drain Commissioner made the request.
So that's again, I'm still struggling with.
Yeah.
All those, I mean, how many different drains are we, drainage districts are we talking about in that upper left-hand blue area?
I don't have the exact statistics, but more than a dozen.
And
They're
as
just
a
not in
result
different
of,
colors for you.
right. But if the challenge is defeated and this new inter-county drain stands, will those people be contributing to the maintenance of the red portion?
Yes. So nothing about the red portion change is, and again, I don't even know if all of the people in the blue are paying because the district is so inaccurate, but it would go from everybody who was paying before, unless their lands truly didn't even go to this drain at all, because then they'd be removed. That could be some of the case too, to include everybody that was paying before, plus everybody else who's contributing water to it, with the exception of the folks in Onondaga Township. Because the board voted no on those.
Right, that little portion in Ingham County.
Correct. And that is not, my understanding is that is not the subject of the appeal.
Okay, thank you.
Welcome. So, so again, this added lands, it didn't really take, it just added to the folks who were already paying so that they would still pay, but more people would also help pay that contributed, that benefited. And that's what the Drainage Board voted. But it doesn't change the municipal or basically the governmental entities of either of those drains. Each of those drainage districts or intercounty drainage districts and drains still lay intact, like Russian nesting dolls. They're still there. You just in more than one drainage district. That is not unique to these counties. That is not unique within the state. Every drain, every county has one of these that has county drains. With that, I'm going to move to some of the due process violations, which is the subject of count 2. Basically, the drain commissioner is arguing that there was a due process violation with regard to his inability to challenge the addition of lands in Jackson County, and then the Meads as to their ability to appeal today. And the Alba Township versus Gratiot County Drain Commissioner case, which was in front of the Michigan Supreme Court, is very specific about that when it comes to due process. There's statutory appeals and protections, and then there's constitutional appeals and protections. And the Supreme Court spent quite some time in that manner talking about that. And really the only time you get to a due process protection is the actual assessment. In this case, there is no due process protections for the Jackson County Drain Commissioner because he's not being assessed personally. This is just the addition of lands to a county. And with the Meads, the only due process protection is the actual apportionment and assessment of benefits. There's a separate hearing apart from all the other ones we've just talked about for them to appeal their assessment. That is protected by due process. That appeal is available to them, but there's no constitutional violation in these appeals. And again, the Alba Township case makes that very clear. Not every statutory appeal rises to the level to due process protection, and these are not one of them. Do you have any questions about the due process section in count 2?
Not at the moment.
Okay. All right, now we get into the denial of equal protection in count 3. And as to any constitutional violations for the ability to appeal, I think we've beat those to death. But there was a new one added in this, and that was the voting rights of each of the drain commissioners in terms of being able to appeal. And in your honor, I've lost your camera. Are you still with us?
I'm still here, yes.
Okay, just checking. So I think the drain commissioner is arguing that it's a constitutional violation that each drain commissioner gets an equal vote on the drainage board, because it's not necessarily fair depending on how much land you have in the county. The way intercounty voting takes place under the drain code has been the same since the recodification of the drain code in 1923. And actually, one vote, one county has been that way even before 1923, when states were, I think, even back to territorial times. For what it's worth, it's my understanding that a member of a drainage board is supposed to act on behalf of the entire drainage board, the entire drainage district, and just not the lands in his county. You know, that's why the Calhoun County Water Resources Commissioner voted yes, even though it would be adding payments or financial responsibilities to his county, because as a drainage board member, you're a fiduciary to the entire district, not just your county. I don't think there's any equal protection violation at all with the makeup. And to illustrate
This doesn't, I mean, ultimately, this doesn't result in the county having to pay anything. It results in the people who are in the county that share in this watershed having to pay.
The county does pay a share for benefit to county roads, but the drain commissioner himself doesn't pay. The office doesn't pay. It's whoever's lands are within it. And so the drain commissioner in Jackson County thinks maybe the legislature got this wrong and it should be by lands. But I don't know that lands are right either. If we play this out, you know, let's say Eaton County had 51% and Jackson County had 49%. Does that mean Eaton County gets to make every single decision and it doesn't matter what 49% says? That doesn't sound right either. How can that be fair? In the current situation, there can be a difference of opinion between the drain commissioners, again, who I say should be acting for the entire district, not just their county. And if they disagree, then the Department of Agriculture is the deciding vote. And moreover, the drain commissioner argues that land area should be the deciding factor. Is that really equal protection? Why not people? Why not percentage of cost? Percentage of cost doesn't equal land area in this situation. Why not miles of drain? There could be a myriad of different situations. And so the legislature decided appropriately to make it one county, one vote, with the Department of Ag breaking a tie. And if for certain things involving cost, take it to an arbitration boards of other drain commissioners. The legislature decided this was the best way to do it. It's been in place for almost a century with no changes or no contest to how it's done, and it doesn't break equal protection. There are no facts that could be presented to change the situation for this county. It be dismissed as a matter of law. The final count, and I am embarrassed that I've taken over an hour talking about this, so my apologies. I am trying to go as fast as I can, is on the violation of the Open Meetings Act. So this was added in the amended complaint. This is not a suggestion of a violation of the Open Meetings Act for the hearing that took place, but after the lawsuit was filed, and it was the meeting to retain counsel. And for this March 16th meeting, the only allegation of improper notice is that the Jackson County Drain Commissioner himself failed to post the notice of the meeting. The Drain Commissioner asked this court to find the Drainage Board in violation of OMA for his own inaction and all actions taken at that meeting, primarily to retain me for defense of this action. And he wants to find that void and of no effect because he did not post the notice. The notice for the meeting was sent about 8.5 hours before the deadline for posting and about 4.5 hours before the end of the business day. The notice was sent to the both the drain commissioner and his deputy. All of the other counties got that notice at the same time, and all of them but Jackson County that are part of the drainage board took the opportunity to post the meeting by the end of the day. The drain commissioner responded before the end of the business day that even though he had received and read the notice, for unstated reasons, he was too busy to post it that afternoon, and also for unstated reasons that he was too busy to attend the next day's meeting via Zoom. All drainage board meetings are special meetings under the Open Meetings Act, requiring only 18-hour notice by posting. This quick notice time allows a public entity to meet quickly in some situations. An example would be being sued and need to quickly retain legal counsel to meet response deadlines. Accordingly, notice needed to be posted for that meeting, the 3 o'clock meeting, by 9 o'clock the night before. The relevant section of the Open Meetings Act is MCL 15.264B and provides that the posting should take place at the entity's principal office. The chair of the drainage board is the deputy director of the Department of Agriculture and Rural Development. They posted properly and on time, physically and electronically. Now, the drainage board or the chair asked that all counties also post the notice as an additional service, but there is no legal requirement to do that. This drainage board has never voted by a vote of this drainage board to require postings at other locations. There are no past practices of the drainage board because it's only met twice. Accordingly, the Open Meetings Act was fully met by when MDARD posted its notice physically and electronically. And there is no question of facts that happened. So summary disposition is appropriate for count 4 because the meeting was properly physically and electronically posted in the principal office of the drainage board. The drainage board did not vote to make postings in any other location and necessity, and an absurd result would occur to require otherwise. A drain commissioner could simply always refuse to post and argue that the drainage board could never meet if it interpreted it a way the plaintiff has requested. I'm afraid something's going to happen at this meeting that I don't want, so I'm not going to post. We can't post for Jackson County. They have to post. They could refuse and we'd never be able to legally meet if OMO was read the way that the Jackson County Drain Commissioner wishes us to read it. That is clearly not what the law says, and we ask in this situation that not only count 4, but for the reasons I spent way too much time talking about already today, all as a matter of law should be dismissed in their entirety.
Thank you. Mr. Donnell.
Your Honor, could we take a 5-minute break so I can use the restroom?
We certainly can.